All right, welcome back to Sunrise Studio. Now, having talked about medical tourism, and we'll take our attention back to the developments in Taraba State. You do remember that the governor has been absent for a while now, and so we'll bring it back to the front burner. Nursing Quakers joins us this morning, Senior Advocate of Nigeria. Morning, I thank you for coming on today.
My pleasure.
You know, when people talk about this, because I know that there was a time they talked about some other governors who were absent, and they had to take it back to the perspective of law, saying, okay, what is the provision? What are they required to do? How should they go about all of this? But now, it looks as though it's gone down for a while, but the law still stands. What are the requirements?
Well, it's very simple. It's a constitutional issue and not political. But regrettably, what we have in Nigeria is that political considerations are used to subdue and override constitutional provisions. Section 189 and 190, if read conjunctively, gives the impression or the picture that the State Executive Council has a burden and a responsibility to inform the House of Assembly of the State through the Speaker that the governor, having worked with him, they have realized that he is incapacitated to carry out or discharge his functions. Now, the burden is actually placed on the Council of State to do that. Now, the Council of State are a group of persons appointed by the governor to work with him, and oftentimes these are commissioners, and they're the ones in a position to observe whether the governor can discharge the functions of his office. Now, having seen that he can no longer perform, it is passed on to the Speaker. The Speaker sets up what is called a medical panel, in line with what the last Speaker also said about the need to also strengthen the medical field or health care. Now, a medical panel is set up of eminent persons, including the medical doctor of the governor himself, to examine and come up with a report whether the governor can no longer discharge his function. That's on one side. Now, 190 places a burden on the governor to transmit a letter to simply say either he's going on vacation or he can no longer perform the functions of his office. So you have these two levels. Now, you can see that essentially it's something that the Constitution has already envisaged. Now, you now have a situation like this. What is expected of the people in Taraba State, the Council of State in Taraba State, is simply to comply with the provision of the Constitution. But what is happening is the political consideration. The governor appointed me. If I blow the whistle, I will lose favor. That's what is going on. So it has now been politicized. So the legal requirement is not being implemented.
But if you look at the way it is now, and then they tell you, because, I mean, if you read comments coming from, is it the acting governor now or the deputy governor? What do they call him?
Yes, the deputy governor.
He also says, look, he's not in a position to determine when the governor is going to return. And so, is that statement, how does that statement fit into the legal provisions?
It's a political statement. Clearly, it's a political statement. And I want to believe that the deputy governor is also playing safe. Now, Nigeria is a very unique country. Unique in the sense that we rather obey laws in breach than in practice. Now, there's a provision there.
Wow.
And then you have the council. The council's responsibility, and you remember that this is not the first time. You see, we have failed as a country to learn from the mistakes of the past. Under President Yar'Adua, it was the same thing. Yar'Adua was ill. The public were aware that he was ill. Certain elements within the government concealed that or tried to shield it from the Nigerian public in order to ensure that the incumbent president did not emerge as acting president. When there's a constitutional provision, all that is required is first transmit a letter. Now look, I can no longer discharge. First, I'm going on vacation, so I will not be in my office. I can no longer discharge the functions of my office. The constitutional provision is always there. But the failure we have, or the difficulty we have, is simply to obey it. Now, the deputy governor is also playing safe. If it comes out, he can't kickstart the process. It is not for him to kickstart the process. If he wants to do it, for instance, he can also do it clandestinely, and that is also not too good. It is actually the Council of State's responsibility to do that, because they are in a position to fly the kite that the governor can no longer discharge the functions of his office. It's as simple as that.
Isn't it a little interesting? In this particular case, I mean, what happened to Governor Suntai was a bit unique in the sense that it was an accident.
Yes.
It left him totally unconscious. it created a problem, a little bit of a problem in the sense that the governor couldn't write to say, I will be away. Isn't that process already the beginning of a problem for the state?
No, no, not really. You know, look at it this way. 189 talks of permanent incapacity, right? Now, the situation you have described can best be described as permanent incapacity, but only a medical practitioner or a team of medical practitioners can come up with that finding. Now, if the picture we have of what transpired is indeed what happened, in other words, he can't write, he can't communicate, he's in a state of coma, it is for the Council of State to raise some resolution and pass it on to the Speaker of the House, who in turn will call to third majority of the House that, look, this is the problem, and set up a medical panel for the purpose of confirming whether the governor can indeed, I mean, it's as simple as, look, no one is saying that the governor can no longer